SJC-13817, Commonwealth versus Sambath, Chhieng.
Okay, Attorney Crane.
Good morning. May it please the court. Edward Crane on behalf of Sambath, Chhieng. The critical issue in this case is whether the defendant adequately established that he faces the prospect of deportation as a result of his admission to sufficient facts. In Granum, this court delineated two ways that a defendant can make this showing. First, a defendant can show that the federal government has taken some step towards deporting him. Second, a defendant can show that the federal government has an express written policy that calls for the initiation of deportation proceedings against him. The defendant made both showings in this case. To satisfy the express written policy standard, the defendant introduced an executive order signed by President Trump. The order is entitled Protecting the American People Against Invasion, and it was issued on January 20th, 2025. In pertinent part, the order states as follows. It is the policy of the United States to faithfully execute the immigration laws against all inadmissible and removable aliens, particularly those aliens who threaten the safety or security of the American people. Further, it is the policy of the United States to achieve the total and efficient enforcement of those laws, including through lawful incentives and detention capabilities. Pursuant to this order is now the express written policy of the United States to deport all removable aliens with criminal convictions. I would argue that this policy is sufficient to satisfy the express written policy standard. It's explicit, it's in writing, and it's signed by President Trump.
What about the admission of sufficient fact versus conviction distinction?
So I think that relates to the adequacy of the warning. And
No. On just sticking with what you said on the executive order.
Well, with respect to the executive order, I think that the admission of sufficient fact would be a conviction under federal immigration law. So this.
That's the answer.
Yeah, yes. The executive order covers, regardless as to whether it's a conviction or it's a, as long as the non-citizen is removable, the executive order says we are going to remove that person, and the admission of sufficient facts renders the defendant removable, and thus the executive order covers his situation.
What do you say to the Commonwealth's argument that the executive order does not completely remove all prosecutorial discretion? Or maybe it's enforcement rather than prosecution, enforcement discretion.
Well, I think the language of the order doesn't suggest that there is any discretion. I think in all instances, there's some level of prosecutorial discretion, but I think certainly in this instance, with this executive order, it suggests that to the extent there is discretion, there's very little. And
well, isn't there discretion inherent in determining which removable aliens threaten the safety or security of the American people? And then also in the efficient enforcement of the immigration laws, isn't there discretion in determining which aliens are sufficiently threatening and how efficiently to enforce the laws?
Yes, certainly, and in passing.
So I guess in light of the discretion built into what is an executive order that is, prioritizing the enforcement of immigration laws, I don't know how that fits the Granum Express written policy against this defendant.
I think that I have 2 points with respect to that. And number one would be just that prior administrations and the prior policies did create priority levels. They'd categorize individuals. These are the individuals that we place at the greatest priority for removal. And then this is the second category, and this is the third category. This executive order eliminates those priorities.
Right, and it leaves it in the hands of, I guess, the immigration officials to determine the priorities on who's the most threatening, how to most efficiently do this. Do we go into a warehouse and collect all of these people, or do we, target, the worst crimes, however that's defined?
Certainly, but I would say that the language of the order is, there may be priority levels that DHS might employ, not noted in the order, but still the policy says there's no individuals that we are going to exempt from deportation. We are seeking to deport all removable non-citizens. So maybe use your discretion in deciding who to pick up first, but the goal is to remove all deportable non-citizens. It's not that we're going to set aside certain individuals and we're not going to seek enforcement on them. It's more so seek these individuals first, but anybody you can get, remove. And I think another issue just with respect to the issue of discretion is, I guess, I don't see any way to actually establish the express written policy standard if the fact that there is some discretion retained by DHS, if that defeats the express written policy standard, I don't see any way to satisfy it, because there's always going to be some level of prosecutorial discretion with respect
You
to.
can imagine an executive order that said, it's going to be the policy of the United States to enforce immigration laws against a particular named individual, right? Like El Chapo, whatever it is. We're going to enforce it, and it's not the same as, dear El Chapo, here's a notice to appear. So that would give that language in Granum some meaning. Yes.
I guess my position with respect to that, though, is that seems quite unlikely that the federal government would issue, and I don't really think that's what the court had in mind in Granum, that the federal government would be issuing an express written policy that singles out one specific individual.
Or a particular crime, right? We're going to enforce immigration laws against people who traffic in cocaine over X amount.
Yes.
And then that would capture, a broader range than my prior example.
Certainly. And I think that would be certainly an example that I think could suffice under the standard.
Somewhere between, here's a statute that that says, certain people are deportable and El Chapo is deportable. How do we draw? How would you suggest we write the opinion as to what the court meant when it says there's this express written policy?
Well, I think that you have to look at what was the goal behind adopting this standard in Granum, and the goal is to allow defendants, non-citizens who face removal as a result of a criminal conviction and haven't been adequately warned, that they are able to, as a practical matter, obtain the relief that they're entitled to before actually being placed in removal proceedings. I think that's the goal. That it doesn't.
It's somewhere more than just it's a statute that requires your violation, because that, I think the majority even said that's not enough.
Yes, and I think that's. I certainly understand why the court did that in Granum, because at that particular time, as a practical matter, just being statutorily eligible for deportation didn't raise the same risk that I think that is raised now with the current policy, which is explicit about removing all removable non-citizens. And again, I guess I would reiterate that.
Before, I just want to make sure you address the second avenue for victory for you, which is that they've taken steps, because they've taken steps here. They just screwed up, right? And they can certainly take those steps again, right?
Yes, Your Honor.
So, I mean, do we even really need to deal with the more complicated policy issue when they've taken steps against him personally and they made a mistake, but it's not like they can't just go out and do it again. It doesn't say successful steps, it just says steps, right?
Some step, I think, is the language from Granum. Some step towards deporting the individual. And I think that we've established that here, considering he was issued a notice to appear. He was in removal proceedings. They have not reinitiated removal proceedings. Sorry, Your Honor. They have not reinitiated removal proceedings, but it's
How much time has passed since this grew up to?
it's been basically a year. Yeah, it's been a little over a year, a few days past. It was January 2nd, 2025, that the motion to terminate was allowed.
And the removal proceedings were pending for a decade, is that right?
For a decade, yes. And I think, again, looking at that standard, though, the step towards deportation standard, it's, again, what it shows is the court is trying to create a way that the defendant can obtain the relief that they're entitled to pursuant to 29D without first having to be in removal proceedings. And I think that really the situation certainly that the court wants to avoid, and I think that would negate the relief that's available through the statute, is what we've seen recently is non-citizens picked up and then whisked away to far parts of the country. And as a practical matter, the defendant at that point would be, well, I guess as a legal matter, they'd be certainly entitled to relief. But as a practical matter, it's going to be almost impossible for them to obtain that if they are in Louisiana is the example that I've heard of the most. But if they're in a jail cell in Louisiana, they are not going to be able, as a practical matter, to file a post-conviction motion in Massachusetts. So the goal of these two different standards are basically to create a situation where the defendant can obtain the relief without first having to be in removal proceedings themselves. And I'm happy to answer any questions.
Could you go back to let's start with the 29D warnings and what happened in this plea?
With respect to the adequacy of the warning?
Yeah.
So I think the adequacy of the warning is fairly straightforward in that it's inadequate because it uses it links the risk of immigration consequences to a conviction as opposed to an admission to sufficient facts. And I think it's quite clear that the legislature amended the statute to make it absolutely clear to individuals who are admitting to sufficient facts that that plea can still result in immigration consequences. And that's why using the language conviction, which is the old language of the statute, is not adequate.
So is there any daylight to the fact that his counsel certified that I gave it to him and he signed that he gave them to me? And there's no room after Petit Homme and some of our case law to suggest that he knew exactly what he was doing and what he was getting and what the consequences were?
Well, the Commonwealth v. Hilaire covers this issue in that the issue there was, can the green sheet replace the oral warning? Mm-hmm. And it says that the green sheet is not adequate. The warning itself has to come from the judge. So if the warning here coming from the judge was inadequate, so I think that resolves the issue with respect to the adequacy. If the court has no further questions, I'd rest on my brief. Thank you.
Okay, thanks.
Attorney Cohen.
May it please the court, Jennifer Cohen for the Commonwealth. The Commonwealth is asking this court to affirm the denial of the defendant's motion to withdraw his plea. Starting with the 29D warnings, I do acknowledge that admission to sufficient facts was left out of that 29D warning, but I would suggest that the decision in Petit Homme left open the fact that the 29D warning in conjunction with the Rule B warning from the Rules of Criminal Procedure Rule 12 together could, in their totality, suffice to notify the defendant.
Does the Rule 12 warning that was given state that admission to sufficient facts will have these consequences?
It is conditional, and I would agree that this court has already analyzed the language in Petit Homme and has said that it is more complicated or perhaps too complicated for a defendant to understand entirely. But I would say where, on its own, I would say where the defendant did receive a 29D warning, although deficient in that it left out the particular tender that the defendant was entering into. In conjunction, the defendant was aware of the potential immigration consequences that he faced. And And I think the court has made clear that what's important is the message conveyed. And I think here the defendant did receive in its totality the appropriate message. I'll turn to,
Given that, steps were actually taken here towards deportation, and there was a technical blip, why is it not enough to meet the Grantham standard?
so I think even in Grantham, it's not explicit, but the wording used tends to suggest that the defendant is currently facing removal proceedings. And I would say that where the removal proceedings against the defendant in this case were dismissed, he's now placed back in the position of all people who are deportable. So I think he's put back in.
He's been before the immigration court for a decade, unlike
Yes,
people you're.
I agree with Your Honor. He certainly was subject to removal proceedings a year ago, maybe a little bit more. So if the court,
Time he filed his motion to withdraw, it had just been a month.
yes. And this is an issue that the court hasn't addressed. I haven't seen this situation come up, but I would say that it's open for the court to decide that there is a temporal link to the removal proceedings and that just isn't here in this case.
Even though he's been individually picked out, and the reason they stopped it was a technical screw up, not any kind of merits-based analysis. And we have, the order and out there as well. It just seems, this seems like he's in the firing line, and steps have been taken. It just seems like, I don't see how you get around that.
It is open, I would agree it's open to this court to find that even the dismissed proceedings in this case would suffice for the defendant to meet his burden. But I would also say that the opposite is true. And I would also say that, I guess, taking this argument then into the executive order argument, the fact that the defendant has not had the removal proceedings reinitiated against him at this stage tends to suggest that the executive order wouldn't fall within this express written policy category that was put into the law in Grantham in 2010.
Well, they can't get everybody all at once. I mean,
Correct.
can't rely on that, can we?
Well, no, and I think that would go to the Commonwealth's point in that even with the strong wording of this order and even with increased budget and increased personnel, the pool of people that may be deportable is still large, and the amount of people that can be detained and deported is finite. So I'm not sure that the executive order makes this defendant's risk of deportation non-hypothetical. And I would say that not determinative, but the fact that these proceedings, which easily could have just been reinstituted simply by providing the defendant a date to appear in immigration court, and that hasn't happened, is somewhat telling of the circumstances here.
Why? We don't know. We would have to speculate as to the reason why he hasn't received that.
Yes, but I would say it's certainly, we would have to speculate, but the fact that it hasn't happened yet, the fact that this defendant, I would suppose, fits all of the parameters of deportation, and that it would be relatively easy to start this process again. It was in place for 10 years. I think it's telling at least that this executive order is not as narrowed as my brother would suggest. And I would say on the executive order, of course, the Commonwealth has put forward a position, and I would agree that if this court decides the defendant met his burden because he was previously subject to removal proceedings, this court wouldn't necessarily have to reach the order, the executive order issue, but I would ask that the Commonwealth be provided some guidance, because this seems to be, there's no guidance in the case law as it stands as to what this express written policy actually is. I did make my argument based on the fact that there is discretion in the order, and I did suggest that numbers come into play, but I would agree with my brother in the reply brief that the numbers aren't the best way to analyze this because they are always going to change. And we could have the same executive order 6 months from now with fewer deportations or more.
Can I ask you to address, and I realize this was not raised in the defendant's briefs, I don't believe in quite the same way, but can you please address the argument by one of the amici that given changes in immigration law and enforcement that actually predate the current federal administration, but that slightly post-date Granum, that the Granum standard, in fact, is just ill-suited to deciding this question, because whereas in the days pre-Granum, there was just people had many fewer, I think the phrase is touch points, where they could be scooped up, but now they're sort of biometric such, so that every time you're fingerprinted and it goes to the FBI, DHS is automatically notified, and so on and so forth. So the so-called purely hypothetical issue is no longer really purely hypothetical, really, for anyone. Can you address that?
I would say, of course, this court is not clairvoyant and couldn't have predicted we'd be in the situation that we're in today. I think it's possible that the court could decide that the change in technology, the change in circumstances, means that this executive order or just the circumstances that we're in changes the landscape of this area entirely. I would point to Justice Cowan's concurring opinion in Granum that clarity is needed, but also that if this court were to decide that this executive order or whatever it may be, fits that express written policy category, then every defendant will have automatically met their burden, and we're in a position where
if they can show that they are removable.
If they can show that they're well, actually, Your Honor, I would say that I guess they would have to show or attest to the fact that they're a non-citizen, and that would effectively allow them to meet their burden. So I can say that, in these cases where you have pleas from the late 80s or the early 90s, where there's no possible way to recreate the record, and I understand I'm not trying to argue against the presumption of regularity, but it would mean that those pleas where we just cannot meet our burden, not because we have a transcript and can see a judge didn't read from the statute, but because no information exists, judges have passed away, all of those defendants will have automatically met their burden here. If there are no further questions, I'll rest on my brief.
Thank you.